Welcome everybody to another You Did the Crime, Stop Crying, You Gotta Do the Time episode of Lockdown 23 in 1. That's right, ladies and gentlemen, today we're gonna witness someone get found guilty and then immediately get sentenced for his crimes. And it's a murder case. Quinton Nixon, 33, fatally shot Tony Westover, 34, on July 25th, 2022. Nixon was arrested a month later. Now, Amy Perry is the sister of Westover, the one that was shot and killed. And she says that Westover and her boyfriend went to an Akron home where an altercation took place and she was shot. No motive or connection between Nixon and Westover has ever been reported. Perry also said that her sister, Westover, texted a friend sometime between 1 and 1:30 a.m., less than an hour before she died, saying something doesn't feel right, something feels off. Westover was gunned down during an altercation sometime between 2 and 2:15 a.m. And a lot of people believe that the altercation was between her boyfriend and Nixon, possibly fighting over a gun, and Westover ended up getting shot. And some people feel as though it was just deliberate killing, so I'm not going to go into the deep debatable section of this case, but we are going to witness this man get found guilty and, of course, get sentenced for his crimes. So let's get into it. If you enjoy all things lockup and crime related, then this is absolutely where you need to be. Hit that like, subscribe, notification bell before you leave, and check out my playlist with many more videos for you to start watching today. Now, before I press play, let me mention this as well. It's very important. 1, he represents himself throughout the whole trial. And many people think that if he had an attorney, man, it might have went a different way. It could have, you never know. But look, I've watched a lot of court trials, and I'm here to tell you, even former judges and attorneys still get their own paid attorney, even though they know the law inside and out. If they're getting paid attorneys and not representing themselves, what the hell makes you think you should? Also, like I said, he's going to be getting sentenced for multiple crimes. And one of them, I believe, had nothing to do with the murder. He got caught with a gun prior to that whole incident. But when you have multiple cases like this, usually they take care of all of them at once. Now, with that being said, let us begin.
I've carefully considered all of the evidence and the exhibits admitted during trial. I've weighed the credibility of the testimony of all the witnesses, including the testimony of the defendant. It is my province to believe all, none, or some of the testimony of each witness, as well as the physical evidence that has been presented and the exhibits admitted during trial. I have considered the physical evidence and whether it corroborates the testimony of each witness in deciding which, if any, of their testimony I choose to believe. I find there is no credible evidence that Ms. Westover threatened or even tried to harm the defendant. There was credible evidence that the defendant had hold of Ms. Westover either by, as to her upper torso, whether by her hair, neck, or shoulder. Ms. Westover was shot 3 times, and the most serious injury which caused her death was a gunshot wound to the back of her neck that was approximately 8 to 10 inches away and included evidence of stippling near the entrance wound, and the trajectory of that propellant was from back to front, right to left, with a downward angle. While the defendant's testimony at times was believable, and there were portions of his testimony that he seemed genuinely convinced of the testimony he was presenting, I find a majority of that testimony was completely self-serving, illogical, and completely uncorroborated by the physical evidence and exhibits admitted during trial. In reviewing Exhibit G of the defense's exhibits, there was no credible evidence that you were injured or that your clothes were torn by Mr. Cruz, the machete-wielding aggressor. While you fled the scene, both Adam Wright and Brian Fielders had already both fled, and you still possessed the firearm. Furthermore, once you dropped from the porch, you leisurely strolled away with no signs of panic or fear that you testified you were feeling during the trial. Your statements to detectives the night you were arrested contained various inconsistencies, not to mention were completely inconsistent with your testimony during this trial. Lastly, your actions in fleeing that night with Miss Westover's purse and the firearm, and changing your appearance and hiding out in your cousin's house for over a month shows a consciousness of guilt. This court is left to weave together the offensive events of July 25th, 2022 from all the testimony, the physical evidence, and the exhibits admitted during trial.
And unfortunately, that's how it is. Even with testimonies from both sides, there's still holes left there for you to weave yourself. And that's one of the hard parts about being a judge or a jury, when there's a lot of holes like that, but you still have to make a decision.
Based on everything presented at this trial, The more logical sequence of events is that for whatever reason, including being high on meth, not having slept for days due to that meth use, and the paranoia that comes with the use of meth, you shot and killed Tony Westover. And after shooting her, you were attacked by Brian Fielder, and when you had him down on the floor, he bit you while trying to get the gun away from you and from your grasp. According to Ashley Bratton, who testified 2 times, and including yesterday, Adam Wright was on his way out of the back bedroom with a firearm and returned, and upon finding you on top of Brian Fielder, hit you with the firearm and then fled. Everyone fled through that back bedroom because Tony Westover was left dead, hanging over the side of that couch, and was blocking the front door. Therefore, I'm left with only one conclusion. The state of Ohio has proved beyond a reasonable doubt that you committed the crime of improper handling of a firearm in a motor vehicle on June 5th, 2022. And
that's the case that was separate from this. Like I said, they're all being put together in one.
Furthermore, by clear and convincing evidence, I'm ordering forfeiture of the Riley Defense, Inc. RAK 47. As to all the charges in the indictment in case 2209-3102, I have considered each count uninfluenced by my verdict as to any other count, and I find that the state of Ohio has proved beyond a reasonable doubt that you did not act in self-defense on July 25th, 2022, and that you were at fault in creating the situation, giving rise to the shooting, or attempting to shoot Tony Marie Westover, and or that you used unreasonable force against Tony Westover. Therefore, I find you guilty beyond a reasonable doubt of murder, an unclassified felony as contained in count 1, and the 3-year firearm specification 1 to count 1. I find you guilty beyond a reasonable doubt of murder, an unclassified felony as contained in count 2, as well as the firearm specification 1 to count 2. I find you guilty beyond a reasonable doubt of felonious assault, a felony of the 2nd degree, as contained in count 3 of the indictment, and the firearm specification 1 to count 3. And lastly, I find you guilty beyond a reasonable doubt of tampering with evidence as a felony of the 3rd degree, as contained in count 5.
Man, it's getting smoky in here.
The court having rendered its verdict, I am prepared to proceed to sentencing at this time, if both parties are prepared also. Before hearing from the parties, I do find pursuant to Ohio Revised
Let
Code
him breathe, Bobby.
4125, State versus Johnson and State v. Ruff, that counts 1, 2, and 3 for merge for purposes of sentencing. I find that the defendant's conduct is of similar import and was committed with the same animus. Pursuant to Ohio Revised Code 2929-14B1G, if an offender is convicted of or pleads guilty to 2 or more felonies, if 1 or more of those felonies are aggravated murder, murder, attempted aggravated murder, aggravated robbery, felonious assault, or rape, and if the offender is convicted of or pleads guilty to a specification of the type described under Division B1A of this section, in connection with 2 or more felonies, the sentencing court shall impose on...
All right, look, he's been motionless pretty much the whole time until something happened. It's not until after he looks over his right shoulder. He gets a little twinge in his eye, and if I were to guess, it's because he probably looked at his mom, old lady, kid, grandma, something, and realized I'm never going to be able to see her on the streets or him on the streets again, and started buckling. Watch.
1, 2, and 3 for merge for purposes of sentencing.
Perfectly
I find that
fine.
the defendant's conduct is of similar import and was committed with the same animus. Pursuant to Ohio Revised Code 2929-14B1G, if an offender is convicted of or pleads guilty to 2 or more felonies, if 1 or more of those felonies are aggravated murder, murder, attempted aggravated murder, aggravated robbery, felonious assault, or rape, and if the offender is convicted of or pleads guilty to a specification of the type described under...
He's probably not hearing a word she's saying, only picturing his family or whoever he looked at vanishing into the wind, if I were to guess. Look, man, I've lived through these type of situations. I know exactly how it feels. Maybe not no murder jank, but still, you know, type of situations have your heart pumping Kool-Aid.
Division B1A of this section.
Yeah,
in connection with
he
2 or
knows
more
it's over.
felonies, the sentencing court shall impose on the offender the prison term specified under Division B1A of this section for each of the 2 most serious specifications of which the offender is convicted or to which the offender pleads guilty, and in its discretion also may impose on the offender the prison term specified under that division for any or all of the remaining specifications.
Ain't no need to cry now, man. You stole a girl's gun, yoked her up, and then stole her life. Right in front of her boyfriend's eyes.
Therefore, I find that specifications to count 1, 2, and 3 do not merge pursuant to 2929-14B1G.
Now we're going to hear the defendant speak before sentencing. Let's see if he takes any kind of blame for all this. Takes blame? Is that the right word? Takes accountability for all this. There we go. Just in time, right before he speaks too. Perfect. He better start off saying, I'm sorry. He better start off saying, I'm sorry.
To Miss Westover's family, I'm not a monster, but I do ask for forgiveness.
There you go. You got to keep in mind, even though he's apologizing and stuff, he's got to watch his words because, I mean, he's been fighting the whole case as though he's innocent and probably still riding out with that in case he wants to try to appeal it or something. I don't know if he can or not, but yeah, even now, speaking to the judge and the families of the victim, I mean, he's probably watching his words.
Nothing I can say is going to help how you guys feel.
That mic is so good I can hear his gulps. That's damn, man. I just heard his stomach acids rolling around in there, man. Bubble guts. Gah. Shouldn't have drank that milk bag before you came in, man.
Please forgive me. To her daughter, I ask for forgiveness. To her mother, I ask for forgiveness. To her sister, I ask for forgiveness.
Let me ask y'all this. Is asking for forgiveness an apology? Right? I don't know. Maybe I'm overlooking it, but I'm not going to just ask for forgiveness. I'm going to say I'm sorry from the bottom of my heart that your daughter lost her life. Can you please forgive me? Bro, come on. You're dragging it out.
It was me against them.
Yup. See, he's still fighting or making it seem as though it was self-defense type of situation. It was me against them.
To my mother and my family, I ask for forgiveness.
And he's done addressing the victim's family.
Forgive me, son.
Oh, she said, I forgive you, son, I think is what she said. Is that what I heard?
have to take responsibility for what the court is holding me responsible for.
Oh, wow, I have to take responsibility for what the court says I'm responsible for.
But it's not. It didn't happen the way that they said it happened.
Not good, man. Not good. That could have added a few more years to his sentence right there. Not being accountable. But you know what? If I'm innocent and I'm about to get sentenced for something I didn't do, I ain't apologizing and asking for forgiveness about shit. I'ma scream it till I go back to the cell block. Y'all got the wrong motherfucker.
I'm not a monster.
Alright, bro. Alright. We get it. We get it.
Anything else, sir?
No, ma'am.
All right, having been convicted of the offenses, the bond that has been previously set is
Bobby!
revoked or remanded to the Summit County Jail. Starting with your notice of your duty to enroll as a violent offender pursuant to 290341 of the Ohio Revised Code. You've been convicted of or pled guilty to a qualifying violent offender offense as defined in 290341 of the Ohio Revised Code. You are required to enroll in the violent offender database personally with the sheriff of the county in which you reside 10 days after being sentenced, if you're not sentenced to a prison term. If you were sentenced to a prison term, you must enroll in the database personally with the sheriff of the county in which you reside 10 days after being released from jail. If you're an out-of-state offender, you must enroll in the database personally with the sheriff of the county in which you reside or occupy a dwelling within 10 days of either one, residing in or occupying a dwelling in Ohio or for more than 3 consecutive days, or 2, residing in or occupying a dwelling in Ohio for an aggregate period in a calendar year of 14 days or more. That being said, I find based on the facts and circumstances of this case in consideration of the relevant sentencing factors, applying the minimum sanction I've determined will protect the public and punish the offender without imposing an unnecessary burden on state or local resources. As to 2206-2276, count 1, improper handling of a firearm in a motor vehicle, I'm imposing 18 months in the Ohio Department of Corrections. I'm not imposing any fines, and the court will take judgment against you for the cost of this prosecution. I'm also
18
ordering,
months.
pursuant to specification 1 to count 1, that the Riley defense RAK 47 be forfeited. As to 2209-3102, the state of Ohio having chose to proceed with sentencing on count 1, murder and unclassified felony, I'm imposing a sentence of life in prison with the eligibility of parole after 15 years. Specification 1 to count 1, specification 1 to count 2, I'm imposing a mandatory prison term of 3 years on each count and pursuant to 2929-14B1G.
Man, I'll tell you what, this judge is like part cyborg.
Those offenses will run consecutive and not concurrent to each other and be served prior to and consecutive with the life sentence that you're facing. I'm using my
Smokes.
discretion to not impose a sentence on specification 1 to count 3, and I'm imposing a 36-month prison sentence on count 5.
So there you have it. She's running it consecutive, meaning he's got to do the 3 years and then the other 3 years and then the 18 months and whatever. Complete all those and then start his life sentence. But there you have it, ladies and gentlemen. That's a wrap. Hopefully you enjoyed today's episode. And my condolences go out to the family of the victim. Very, very sad situation. And hopefully realize one thing more than anything. And that is, if you're in the mix of things in the courtroom, man, it's best to get a paid attorney. Stay free.